Welcome to the Supreme Court of the United Kingdom, where we are today beginning the second day of a hearing in the proceedings between the Financial Conduct Authority and a number of insurance companies. The basic issue in the proceedings is whether the insurers are under a liability to indemnify insured parties who took out business interruption insurance with them and then sustained losses as a result of the COVID-19 pandemic. We're currently hearing arguments presented by the insurers, and when we closed yesterday afternoon, we were hearing Mr. David Turner, Queen's Counsel, on behalf of Royal and Sun Alliance. So I'll turn now to Mr. Turner.
My Lord, last night I left RSA 1 with just one further topic to cover, which is the question of causation as it specifically relates to RSA 1. And in our written case at paragraph 75, subparagraph B, references B, tab 9, page 319, we suggest that for the purposes of testing causation under RSA 1, it is sufficient to remove the disease within the specified proximity and any measures to contain it imposed as a direct consequence of the local disease and specifically upon holiday rental accommodation. Now, in its respondents case, the FCA seizes upon what we say in paragraph 75B as being directly inconsistent with what Hiscox says in its case. And one can see that in the footnote 438 to the FCA's case, reference B, tab 10, page 468, where the FCA says that Hiscox's position on its hybrid clauses is that one strips out the consequences of the restrictions, not the consequences of the disease. Now, inevitably, Mr. Gazeman is right in his written case, and I am wrong in mine. We were guilty, as is the FCA, of conflating two different causal inquiries. In the context of RSA 1, there are two discrete steps. Each is subject to the words "as a result of." The first step is to ask whether the disease within the specified radius proximately caused any relevant closure or restrictions placed upon the premises. The second, and applying the contractual definition that one sees at Bundle C, tab 15, page 1186, to which I took you yesterday, that's the contractual definition of loss of gross revenue, is to ask whether such closure or restrictions were the sole cause, and I emphasize sole cause, of any loss of gross revenue. If and to the extent to which there was any concurrent cause of the loss of gross revenue, which could include the general presence of COVID-19 in the country and also include the presence of COVID-19 within the specified radius, COVID-19. Sorry, was that my Lord Briggs? Right, I'll carry on. If and to the extent to which there was any concurrent cause, including the general presence of COVID-19 in the country and also including the presence of COVID-19 within the specified radius, that's a concurrent cause of the loss of gross revenue, then the answer to the second question could only be no. And we would test the position in this way. It is or should be common ground that RSA 1 does not provide cover for loss caused by disease in itself, but only for loss caused by restrictions or closure placed on the premises caused by disease within the specified radius. But if you conflate the two causal inquiries and thereby reverse out disease in its entirety, the effect would be to reduce the causal linkage between the loss and the restrictions to the status of a proviso. I suspect Mr. Gazeman will have more to say on that subject and how one approaches the question of causation in hybrid clauses. Could I turn then to RSA 3, which is the Eatongate commercial combined wording. One finds that wording in bundle C at tab 16 for those using tabs, and it starts. My lord, I'm getting feedback because I suspect someone is not muted. It starts at page 1200. My lord, by way of summary, our position in... My lord, Lord Legate.
I'm a bit slow and behind you, Mr. Turner, but did I understand the gist of what you've just said to be, before you moved on, that if there were restrictions that were a result of both cases within the radius and cases outside the radius, to the extent that those restrictions would have been imposed because of cases outside the radius anyway, cover is defeated?
Yes, because the but-for test is not satisfied at the link between the restrictions and disease.
And then so is it on your case, even if the cases within the area, let's suppose, hypothetically, would have been sufficient on their own to result in the restrictions?
Yes. Not
Well, that's a very counterintuitive result, isn't it?
Well, we say that is the consequence of applying the but-for test, my lord.
Well, perhaps that's a reason why we should look pretty closely at the trends clause and see whether that's really how it is to be construed.
Well,
maybe somebody else is dealing with that particular aspect.
With RSA 1, there is no trends clause. It is purely the definition of loss of gross revenue, which requires that the loss, the sole cause of the loss, be the insured peril by the time one's manipulated the wording.
Right, okay, thank you.
My lords, RSA 3, by way of summary, first point by way of summary is that disease cover is provided again only as an adjunct to the primary business interruption cover, which is itself parasitic upon insured material damage to or loss of the insured's property. Secondly, this policy only responds to the consequences of a notifiable disease, either at the premises or within the specified radius premises. Insofar as the disease is outside the specified radius, then it does not form part of the insured peril. Third, loss due to epidemic is excluded from cover. And fourth, to the extent that it matters, the word following should be construed as requiring as a minimum but for causation. We say it should be construed as requiring proximate causation. Now, I take you to the relevant policy terms, and if we start at C, page 1201, you'll see the contents list. Notably missing from the contents list is section 2, which is in fact the business interruption cover, but you will see that there are various types of cover provided by means of different sections, each of which is operative only if indicated in the schedule. So again, we have a composite policy. The first section is property damage cover, followed by business interruption cover, which, before one comes to its extensions, is parasitic upon the insured property damage cover. Provision is also made for employers and public liability covers, as well as a number of standard bolt-ons, such as goods in transit, money and assault, and commercial legal expenses. Again, we see a one document provision on page 1202, which refers specifically to the general exclusions in the context of the entire policy being read as one document. On the following, on page 1207, at the top of the page, you will see again a signpost towards the general exclusions, to which the reader is encouraged to pay special attention. Section 2, business interruption, starts at page 1231. And one finds that halfway down the page on 1231, section 2, business interruption. And the second set of bold text draws specific attention to general exclusions which apply to this section. The definition of business interruption, or the standard definition, is to be found at the bottom of 1231 and going over to page 1232, and is damage-based, as one would expect. There is a definition of incident which is relevant because the trends provision refers to incident on 1232, and again the definition of incident is damage-based. The BI insuring clause, the main BI insuring clause, is at page 1233, the third block of text under the heading of cover. And that refers to business interruption, so the standard BI insuring clause is through the reference to the defined term of business interruption, referring effectively to insured damage. Basis of claim settlement starts on 1233, slightly lower down, and there is a trends provision. Just check the reference for that. My lord, I'll come back to the reference. Sorry, the trends provision actually is where you would not expect it to be. It's at the top, in between the heading the definition of vicinity on page 1233 and the insuring clause. So there's a special provision tucked away without its own heading, which is a trends provision, and the trends provision is in standard form but refers to an incident. Again, it is common ground for the purposes of this appeal that the trends provision is to be read as if the word incident is replaced by a reference to the insured peril, and that is to be discerned from the judgment below at paragraphs 119 to 122, bundle C, tab 3, page 71. The infectious diseases extension starts at 1237 towards the bottom of the page. One can see the extensions start on page 1236 with a reference to cover being provided under the section being extended to include, and these are automatic extensions where business interruption cover is provided. Extension 7 is the infectious diseases extension. An indemnity in respect of interruption of or interference with the business during the indemnity period following A1, any occurrence of a notifiable disease as defined below at the premises, or attributable to food or drink. 2, discovery of an organism at the premises. 3, an occurrence of a notifiable disease within a radius of 25 miles of the premises. And B, C, and D are familiar extensions, again, premises related, which will be familiar to you, and I will leave you to read, if I may. The infectious diseases extension, so extension 7, whether it is dealing with infectious diseases or other aspects of infectious diseases, is subject to what are in fact special conditions, but are preceded by the heading additional definitions in respect of notifiable disease. The first is the definition of notifiable disease itself, and that is in the same terms that you saw yesterday in relation to the Amlin policy. The second reads, for the purposes of this clause, the indemnity period shall mean the period during which the results of the business shall be affected in consequence of the occurrence, discovery, or accident. That's a reference back to the perils in the extension itself. And item 4 is we shall only be liable for the loss arising at those premises which are directly affected by the occurrence, discovery, or accident. And then what should be a separate special condition is a redefinition of the term maximum indemnity period. Sectional exclusions appear at page 1240, there are no relevant sectional exclusions, but what is relevant is that where the sectional exclusions are introduced 2/3 of the way down page 1240, there is again a reference to the need to see the general exclusions. Next in time, page 1285, within the general terms and conditions of the policy, 2/3 of the way down, under numbered general condition 10.9, but forming a separate unnumbered general condition, is a general condition in relation to interpretation. Sub-condition E makes the point that headings are for reference only and shall not be considered when determining the meaning of the policy. The general exclusions themselves start at page 1290 and again start with a reminder that those exclusions apply to all sections of the policy unless stated otherwise. General exclusion L, which is the general exclusion with which we are concerned at 1292, is to be found, page 1292, starts with the rubric applicable to all sections other than section 5 employer's liability and section 6 public liability, and then below that one sees the words contamination or pollution clause. My lords, in the divisional court, the FCA took the point that the words applicable to all sections other than section 5 and 6 were part of the heading, and therefore one could discern from that that one was entitled to look at the headings rather than being bound by what is said in the general conditions. In our submission, those words applicable to precede but are not part of the heading, they are simply directory. The point taken by the FCA was, with respect, an example of what Aristophanes might have described as hair-splitting wordsmithery. Under the general exclusion, there are 4 provisions, which are helpfully numbered A, B, then AB, so I will refer to the second A as A bis and the second B as B bis. A contains the operative exclusion. The insurance by this policy does not cover any loss or damage due to contamination, pollution, soot deposition, impairment with dust, chemical precipitation, adulteration, poisoning, impurity, epidemic and disease, or due to any limitation or prevention of the use of objects because of hazards to health. It might be observed that the draftsperson is obviously allergic to the use of punctuation. B says that the exclusion does not apply if such loss or damage arises out of one or more of the following perils, and I'll leave you to read those. And then we come to A bis. If a peril not excluded from this policy arises directly from pollution and or contamination, with pollution capitalized, contamination capitalized, and both words in bold, any loss or damage arising from that peril shall be covered. My lords, I should observe at this stage that neither pollution nor contamination is a defined term in this policy. And indeed, those words are capitalized and emboldened at random in different places within the policy. Sometimes they're capitalized, sometimes they're not, and sometimes they're emboldened, and sometimes they're not, and sometimes you get both or neither. B bis is the final part of this exclusion. All other terms and conditions of this policy shall be unaltered, and especially the exclusions shall not be superseded by this clause. Can I start next with the scope of the insured peril? The starting point, as my Lord Hodge observed in Impact Funding Solutions at paragraph 7, the reference, I don't ask you to turn it up, is bundle G tab 60, page 1031, where Lord Hodge said the extent of insurer's liability is ascertained by reading together the statement of cover and the exclusions in the policy. An exclusion clause must be read in the context of the contract of insurance as a whole. It must be construed in a manner which is consistent with and not repugnant to the purpose of the insurance contract. In our submission, that approach is consistent with that articulated more generally by Lord Justice Chadwick in Taylor and Reeve-Duat Music, which you will find in Bundle E at tab 39, page 1140, at paragraph 27, where he said in the context of potentially inconsistent clauses that the court must start from the premise that the parties intended that effect should be given to each of the clauses in their agreement, so that to reject, and he at this stage quotes from Lord Gough's opinion in the Yin Yi case, Yin Yi commercial bank case, to reject one clause in a contract as inconsistent with another involves a rewriting of the contract, which can only be justified in circumstances where the two clauses are in truth inconsistent. And as Lord Gough went on to say in the Yin Yi case, and quoted by Lord Justice Chadwick, that the overwhelming probability is that on examination, an apparent inconsistency will be resolved by the ordinary process of construction. Paragraph 40 in the same judgment, so the Taylor case, Lord Justice Chadwick went on to say that the question in each case is whether the provisions can sensibly be read together, whether a reconciliation of provisions can conscientiously and fairly be achieved. I pause there to note that fairness in our submission connotes the principled application of the relevant rules of construction, not, as the FCA would have it, avoiding a result which one party doesn't like. We say that the starting point, therefore, is to read the coverage clauses and the exclusion clauses together to ascertain the scope of the cover that's being provided under the disease extension. As to that, what we submit is that it is perfectly possible to construe the infectious diseases clause and exclusion L together. They give rise to a coherent scheme whereby the consequences of local occurrences, and I use the word local as a convenient and relative shorthand and not as an invitation to the FCA to suggest that the effect of a 25-mile disease radius is not very local and therefore must be taken to embrace the entire country, whereby the consequences of local occurrences of disease within the 25-mile radius are covered, but the consequences of epidemics and of disease outside the specified radius are not. This, and only, my Lord Legate.
It's asking, it's a totally unreasonable ask of the reader of the policy, isn't it? To expect somebody, when they read the disease cover that they've got, to construe that in the light of some small print that appears 50 pages later amongst general exclusions. It's an absurd approach to construction.
Well, my Lord, I submit it's not. And it's not because the reader's attention is drawn repeatedly to the general exclusions. And to say that one shouldn't take account of the general exclusions because they're to be dismissed as small print, it is effectively to draw a red line through the general exclusions, despite the fact that they are signposted repeatedly during the course of the policy. To dismiss
another way of approaching it is to say that when you read epidemic and disease here, you don't read it as cutting down the cover that you've already got in your disease clause.
Well,
it's applicable to other things.
Well, there is nothing else to which the exclusion in respect of epidemic with respect could relate. And I'll come to
the entire policy.
Not as far as I have been able to identify. No doubt Mr. Edelman will correct me if I'm wrong.
Well, then why is it in the general exclusions and not put in the clause which it's the only clause you say it's relevant to?
Well, my Lord, that it could have been better expressed in the general exclusions, but it's not. It is where it is. That doesn't provide a justification for putting a red line through it. There is, in our submission, no authority that would support taking such an approach to general exclusions, that effectively they are to be dismissed as small print. And that goes far beyond any principled approach to construction. If I may, we say that on its face, general exclusion L seeks, my Lord Briggs.
Yeah, assuming that the two clauses can be read together in the way you say, what if the outbreak within the 25-mile radius is itself part of an epidemic? Does that mean that the epidemic exclusion excludes it? Or do you read them the other way around, that epidemics generally are excluded, but not ones which happen within 25 miles?
Only the latter, because epidemic generally is excluded. There is no cover for disease outside the 25 miles. So if one is seeking to give effect to the exclusion, we say that is how one construes it. We say...
So I understand. So if the occurrence within 25 miles is part of an epidemic, it's excluded. But if it's not part of an epidemic, it's not excluded. Is that right?
So that is right.
And how does one tell whether an occurrence is or isn't part of an epidemic?
Well, that is, my lord, a question of fact to be determined in any given case. But there may be issues as to whether something is an epidemic on the margins, but not in the context of COVID-19 and a worldwide pandemic, which is simply an aggregation across the world of national epidemics.
Thank you.
What we say is that on its face, Exclusion L seeks to exclude loss due to epidemic. We say that not all notifiable diseases have any obvious potential to result in something which can properly be characterised as epidemic. And you were taken yesterday briefly by Mr. Crane to the list of notifiable diseases, which you will find at the back of the regulations at bundle E, tab 5, page 88. And you were taken there before an intervention that was both misconceived and unfair. It was misconceived because what Mr. Edelman had forgotten was that the ruling that he was referring to was made in respect of his attempt to call expert evidence as to the meaning or the likely epidemiological consequences of specified diseases within the ecclesiastical policy, as if the reasonable person reading that policy would have in his back pocket a very eminent epidemiologist to tell him what the potential implications were, rather than relying upon the court as the proxy of the reasonable reader of the policy to understand what the implications of the specified diseases might be. It was unfair because Mr. Crane, uniquely amongst Insurers' Council in front of you, was not aware of that particular genesis of the particular point. And the court below held that Mr. Edelman was seeking to introduce extraneous evidence to support his construction. But if one looks at the list of notifiable diseases, there are a number which have no obvious potential to result in an epidemic. For example, acute encephalitis, rabies, tetanus, and even malaria can be discounted as something which could realistically give rise to an epidemic within the United Kingdom. And Legionnaires, although you might get a number of people infected who have been to the same building, being an environmental pathogen, Legionella, the chances of that causing an epidemic are remote. We say that the infectious diseases extension, so far as relevant, is intended to provide cover only for occurrences of an infectious disease either at the premises, subclause A1, which the FCA accepts. It is a fortuity which is focused on the disease at the premises and not a wider outbreak. It's Respondents' case at paragraph 194, B10, page 394, or within 25 miles premises. And we say there is no clue in the language that allows a syntactical distinction to be drawn between the nature of the 25-mile radius peril and the peril at the premises. If the 25-mile radius provision is construed as delineating cover for only a local outbreak of a notifiable disease, there is nothing inconsistent or remarkable about insurers wishing to exclude liability for an epidemic as a qualification to, but far from a negation of, the disease cover. It certainly can't be suggested that it is repugnant to the... My Lord Briggs, sorry.
No, sorry. The exclusion in A isn't just of epidemic, is it? It's a comprehensive concept involving epidemic and disease or due to any limitation or prevention of use of objects because of the hazards to health. Are you sort of quietly accepting there may be some repugnancy and the rest of it, but epidemic survives?
Yes.
Or are you in the whole of the very broad ambit of that apparent exclusion?
No, I accept that you can't read that clause as excluding liability for disease, full stop, because that would be in direct conflict with the disease cover, and those two clauses could not live alongside each other in those circumstances. But the fact that one can't give effect to the exclusion in respect of disease does not inhibit one from giving effect to the exclusion in respect of epidemic.
Thank you.
My Lords, as I was saying, it cannot be suggested it is repugnant to the disease cover for insurers to impose a qualification on the disease cover excluding liability for epidemic. And indeed, if I could ask you to look at the FCA's Respondents case at paragraph 191, Bundle B, tab 10, page 393, what they say in terms is, it is rather that in circumstances where the policies contemplate and naturally include disease outbreaks that could amount to a pandemic, relevant purposes, that is to an epidemic, because pandemic is an international concept. If the parties intended that there would effectively be no cover for a pandemic disease when it becomes a pandemic disease, the policies would have said so. And it goes on to say there are various ways in which that could have been done. And just stepping back, we say there are the following pointers. First, the policy repeatedly makes clear that the cover which it provides is subject to general exclusions. There are two such reminders within the business interruption section itself, as well as at the beginning of the general exclusions and at the beginning of general exclusion L. Second, the divisional court seems to have taken the view that an exclusion clause cannot be read so that it cuts down the specific covers provided in the insurance. Reference for that is judgment paragraph 115, bundle C, tab 3, page 70. But while it may be necessary to ensure that exclusions are not repugnant to the cover provided, the fact that an exclusion qualifies and therefore, at least to some extent, cuts down the cover otherwise provided is unremarkable. That is the purpose of an exclusion clause. Third, given that general exclusion L does not apply to any liability covers within the policy, it is difficult, if not impossible, to see what other cover beyond the disease extension it might apply to. As we've noted in our written case, the court approached the general exclusion having effectively already determined that it should adopt a construction of the disease extension, which avoided the result that there should be no effective cover if the local occurrence were part of a wider outbreak. Judgment paragraph 107 and following, C, page 68. Even if that were a tenable construction of the disease extension itself, it would not render the exclusion of epidemic repugnant so that it must be disregarded. But that is effectively what the divisional court did. The reliance on subclause A bis and B bis, and my lords, it may be helpful to have those available to you, page C, page 1292 at this point, provide no reason, we say, why the exclusion for epidemic should not be respected. The reference to pollution or contamination cannot be read, or shouldn't be read, as encompassing everything in subclause A. You can only get there if you read the words pollution or contamination in subclause A bis as referring to the heading of the disease exclusion, or sorry, the pollution or contamination exclusion. But you're not allowed to refer to the headings. Second, pollution or contamination, as I've noted, are not defined terms. But even if the FCA were right to say that subclause A bis is to be construed as referring back to the entirety of subclause A, the submission misunderstands the nature of that subclause just as much as the divisional court was wrong to accept the argument advanced for the first time in the FCA's oral submissions below, that subclause B bis means that the terms of the exclusion are not intended to overwrite express grants of cover. Judgment paragraph 117, Bundle C, page 70. The divisional court's approach would have the remarkable, and we submit with respect, nonsensical effect that having set out in subclause A number of exclusions which could only be of relevance if and to the extent that they qualify express grants of cover, the parties then effectively draw a red line through the entirety of that subclause by means of what is said in subclause B bis. There is, we say, a clear and coherent structure to the general exclusion as a whole, even if the drafting could have been improved. Subclause A sets out the exclusions from cover. They expressly apply to all sections save the liability sections. Subclause B sets out exceptions to those exclusions. Subclause A bis provides a right back of cover in respect of non-excluded but ensuing causes. So where a peril not excluded arises directly from pollution and or contamination, to use the words of the clause, then there's a right back of cover. Thus, by way of illustration, if contamination of electrical equipment with soot led to a short circuit and a fire, the ensuing peril of fire would be covered. But, and this is where subclause B bis comes in, subclause B bis qualifies any such right back by stipulating that it is subject to all other terms and conditions of the policy. That this is the purpose of B bis is signposted, we say very clearly, by the explicit emphasis in B bis to be found in the words, especially the exclusion shall not be superseded by this clause. And therefore the words this clause in B bis can only sensibly be a reference to A bis. My Lord, the FCA invokes contra proferentum to avoid going down that process of construction. We say that that is an unprincipled approach. If you get to a proper construction by applying the normal rules of construction, you don't have an ambiguity about the parties' agreement, and therefore there is no scope for invocation of the contra proferentum principle. And just for your Lordship's reference, we rely on paragraph 13 of Lord Justice Auld's judgment in McGeehan and Direct Travel, Bundle H, tab 7, page 112. My Lord, on following, I largely align myself with what Mr. Healy said yesterday afternoon. The FCA is right to concede that following connotes at least a causal requirement, but it mischaracterises what that requirement is. The phrase, the unhelpful phrase, looser causal requirement than proximate cause is not only unhelpfully opaque, but it's actually, with respect to mealy-mouthed way of suggesting that it indicates no requirement for any real causal relationship at all, whether proximate or but for. We rely upon what my Lord Hodge said in McGann's Executors, for which you already have the reference, and we also say, like Amlin, that the word following has to be construed in its context. For RSA 3, the true meaning of the word following and the necessary causal collection it connotes is signalled by clauses 2 and 4 of the so-called additional definitions, which refer to the results of the business being affected in consequence of the occurrence. Those are clear words requiring at least but for causation. We say that they are words consistent with proximate causation, and also in item 4, the loss arising at the premises directly affected by the occurrence. We've set out our arguments there in paragraph 47 of our written case B, tab 9, page 309. The divisional court concluded that neither of those additional definitions indicated a requirement for proximate causation because it said the occurrences of disease would not have a direct effect on the business. Judgment, paragraph 96, Bundle C, tab 3, page 65. With respect to the divisional court, that conclusion muddles both factual and legal causation. The logical consequence of the divisional court's analysis is that it would not matter what causal words were used because the effect on the business of the disease could only ever be indirect. But such an approach not only conflicts with section 55, subsection 1 of the Marine Insurance Act, but it conflates proximate causation with being the last event in the causal chain. So in RSA's submission, by way of conclusion, it does not matter whether proximate or but-for causation is required by use of the word following. The simple point is that neither requirement is satisfied unless the insured can establish that it would not have suffered the relevant interruption but for the occurrence of notifiable disease within the relevant radius. My Lords, unless I can assist you further, those are my submissions. My Lord, Lord Briggs.
One final question. We're back to repugnancy again.
Yes.
Are you aware of any authority which assists on the question whether when testing whether clause A is repugnant with clause B, you can do a sort of blue pencil test to the apparently repugnant clause so as to preserve such bits of it as may not be repugnant? Or have you got to look at the clause as a whole?
Well, my Lord, the question is whether you can fairly read the two clauses alongside each other. And that may involve elements of applying a blue pencil test, because one may be writing down one of the clauses, but that is a preferable approach to simply taking the red pen and putting it through the entire clause. And it's important to note that subclause, the exclusion L, deals with many things in subclause A. It doesn't just deal with disease, it deals with epidemics. It doesn't just deal with disease and epidemics, it deals with lots of other things. And one is to be taken as inferring that the draftsperson expected or intended, subject to arguments about repugnancy and making sure that these clauses can live alongside each other, the parties to focus on those bits of the clause that are relevant in the particular context.
Thank you.
Thank you very much, Mr. Turner. I think we turn next to Mr. Gazeman, Queen's Counsel, on behalf of Hiscox.
My Lords, can your Lordship see and hear me?
Yes, perfectly.
Thank you. At this stage of the appeal, there is a change of focus. We move away from disease clauses to a different type of clause. The clause is to be found at C6, page 401. The operative Hiscox clause is not a disease clause, which is what the FCA originally called it, and it's not much more informative to call it a hybrid clause. Not only is it not a disease clause, it is also not an emergency or a danger clause either, although the FCA mixes it up in the discussion with quite different clauses which expressly refer to those perils. This confusion enables the FCA to claim that Hiscox's clause, quote, responds to an external emergency in the world, close quote, FCA Respondent Case 387. The Hiscox clause is what its title calls it. It is a public authority clause. I will use the abbreviation PA. Its essential nature is to respond to PA restrictions imposed in certain circumstances. Vermin, drains, food poisoning, disease, death by human hand. The detection of mouse droppings in a leisure centre is not an external emergency in the world. The clause raises its own distinct questions, both of construction and of causation. The first is obvious. As to causation and the counterfactual, the court below essentially gave the same answer for all insurers. That does not have to follow. The insurers with disease clauses have made their own submissions, and I adopt them where appropriate. Although I am the fifth counsel to address your lordships, I am naturally only concerned with Hiscox's distinct position. The structure and nature of the Hiscox Public Authority Clause give rise to a particular, and we submit, compelling argument that the court below constructed the wrong counterfactual in Hiscox's case. The idea, when it comes to Hiscox, of relegating the public authority element in the public authority clause to a merely, quote, adjectival, close quote, status, FCA Respondents Case, paragraph 428.1, that relegation is not possible as a matter of construction without eviscerating the clause. Now, the FCA's appellant case, paragraph 29, and it's worth looking at this, B239, justifies the decision of the court below on this very point in these terms, underlining it. The parties intended that the insured recover for losses that would have been incurred even without the public authority restrictions. Paragraph 29, my lord. Now that is very striking. The FCA's contention is that the insured recovers under a public authority clause losses which would have occurred without the public authority restrictions. How can that be right? Hiscox's promise was to hold insureds harmless against loss caused by PA restrictions of certain types, what my Lord Legate in Sartex called the specified loss or damage, emphasising the word specified, paragraph 35 of that judgment. Now, those very public authority or PA restrictions are said to be inessential to the breach of the insurer's promise to hold harmless against that, quote, specified loss, unquote. The breach occurs anyway. Now, whatever that contract is, my lords, it's not a contract of indemnity. The FCA is driven to argue the correctness of this proposition to support its own appeal on the pre-trigger downturn, but in the context of Hiscox at least, it exposes the fallacy and the counterfactual which it advocated and which the court found. We call it the FCA's 13th chime point. See paragraph 132 of our Respondents case. One further introductory point. Whether and to what extent it was predictable that the UK would be hit by a serious outbreak of a notifiable disease. In the case of Hiscox, that is not the question. The Hiscox clause, as we can see, insures against the consequences of PA restrictions of certain types. So the question is as to the extent to which the government reactions to the pandemic in March 2020 can have been objectively intended as risks which the parties were to insure at the time of contracting. The FCA inevitably admits that these actions were unprecedented in this country. That's Respondents Case 156. At 391, it implicitly recognises that the parties could not have had this, quote, draconian legislation, close quote, in mind. Mr. Crane has covered this ground, and I just make 4 points. First, the FCA conflates the disease with the government reaction, saying that COVID is not different in kind from SARS. Respondents Case 391. That point may or may not be relevant to the disease clauses, but a clause ensuring PA restrictions requires the parties to have intended those risks to be transferred, and they were different in kind to anything previously known. Second, even assuming that all the powers buried in the 1984 Act are to be treated as reasonably available to the parties, the question is not as to the existence of those powers, which are in the most general terms, but the possibility of their exercise in the way in which they have been. All that the FCA can say, Respondents Case 159, is that while the regulations are unprecedented, quote, they did not come from nowhere, they did not appear out of nowhere, close quote. Third, I should draw attention, but I shall have to ask your lordships to read this in your own time, to paragraph 138 of the judgment, which expresses the matter much more guardedly, finding, as regards a disease clause, that all that could reasonably be expected at the date of the contract was that the outbreak of a SARS-like disease would have, quote, an impact or some impact, close quote. That is a very restricted finding. Fourthly, as others have submitted, that a risk is foreseeable does not mean it is intended to be covered. That question is answered by the contract. In the case of Hiscox, this question arises in relation to what is conceded to be an extension to a property policy. It is easy to imagine a PA's reaction to Legionnaire's disease in the waterworks of a property being a covered risk. Lockdown in the wake of a worldwide pandemic is totally different. So much, my lords, by way of introduction. Given the very limited time I have, I cannot cover all 8 of our grounds of appeal orally. I will have to be selective, and I will focus on the first 5. As to those which I do not cover, I naturally refer your lordships to our written case, familiarity with which I also assume in the submissions which follow. So I want to turn first to ground 5. Is Hiscox 4 triggered? This is a coverage question. Questions of causation which arise in this question arise within the peril and determine whether or not the peril has occurred. The question is whether, on their true construction, Hiscox 4 policies respond to the March 2020 government measures. The Hiscox 4 policy contains a different PA clause to the one which I showed your lordships. This one has a within 1 mile stipulation. We may take as an example the wording at C22 1558. That wording has both an NDDA clause, a non-damage denial of access clause, which is at page 1559, and a PA clause, which is at 1560. Although this is only true of some Hiscox 4 policies, the fact that they also had an NDDA clause in. Now, as your lordships will have read in the judgment, the court held that the NDDA clause did not respond at all in any Hiscox policy for several reasons, as we will see, including the fact that nothing that occurred within the 1 mile radius caused the government measures. We'll look at that in due course. That's judgment 418. The FCA does not appeal against the NDDA clause holdings. However, the court held that the Hiscox 4 PA clause did respond. Hiscox appeals against that conclusion. The court reached its conclusion with express hesitation. It was no doubt mindful of the fact that the Hiscox 4 PA clause has much in common with QBE3, which the court held fell the opposite side of the line, as well as with the Hiscox NDDA clause, which fell the opposite side of the line. Whether the court was also affected by the temptation of elegance, it would be presumptuous of me to say. Now, Hiscox argument proceeds in these stages. Some of these points have been made by others, but in the context of Hiscox 4, it is worth seeing just how many line up. So we've got 1560, I hope, on the screen for those who are reading on the screen. And first, the relevant element of the insured peril under Hiscox 4 is an occurrence of a notifiable disease within 1 mile of the business. And I will call that the stipulated occurrence, because that's what it is. Secondly, as has just been submitted, many notifiable diseases manifest themselves locally and not on a broad scale. Legionnaire's disease, tetanus is a notifiable infectious disease, an outbreak of German measles at a school, and so on. So it is a serious exaggeration for the FCA's appellant case 134 to say that insurers' construction gives, quote, illusory cover for notifiable diseases, close quote. It is also wrong, as we have seen, for the FCA's Respondents Case 387 to describe Hiscox 4 as expressly contemplating a serious emergency. Thirdly, the fact that the parties, as has been said before, may have contemplated that notifiable diseases could be local or widespread does not mean that they intended to cover all incidents of all such diseases. That remains the question to be answered. The FCA's Respondents Case 312 recognises that local cases met by local measures may be, quote, more typical, close quote. It then exaggerates by saying that the, quote, unique identifying characteristic of notifiable diseases is their possibility of spreading broadly, close quote. Food poisoning is a notifiable disease, so is tetanus. Again, the Respondents Case, the FCA's Respondents Case 204 says, quote, disease outbreaks do not occur in a particular place, close quote. Really? That's not right either. Only if you assume with hindsight that a pandemic or something similar is the paradigm, or an epidemic is the paradigm. Fourthly, my lords, if we can go back to, or perhaps we still have it, 1560, the public authority in this clause is the same type of PA as the one which imposes restrictions in the event of vermin, food poisoning, drains. In other words, a local authority reacting to a small-scale local event.
Well, what about A, murder or suicide?
Well, the event may not be local, my lord, but if the murderer, as it were, comes to a house which is near the premises, then the murderer is local. I accept that to that extent.
Well, all I had in mind was clearly it wouldn't be a local authority; it would be the police, presumably. Who would...
I'm sorry, my lord. I'm using public authority. I'm sorry, I did say local authority, and of course I should have said public authority, but it would be the local police force, my lord, or it would be likely to be, in the event of a murder or suicide. My lords, in our appellant case 112, I haven't got time to take your lordships through it, we analyse in detail the other covers within the clause, A and C, D and E, and we show how, of their nature, and by reference to the relevant legal powers, they contemplate small-scale local events. And I hope paragraph 112 doesn't misspeak in the way that my Lord Reid pointed out that I had a moment ago in relation to the police. The point here is expressed in the Latin maxim nosciter a sociis. And the fact that the public authority is capable of including a government does not prove that this clause was meant to cover national events. Fifthly, my lord, Mr. Salzido addressed your lordships on the meaning, or the natural meaning, of the word occurrence in the insurance context, even before one gets to the 1 mile limit, as a textual indicator of specificity. He referred to the dictionary, and interestingly, and I don't believe this has been resiled from, the FCA skeleton below, in footnote 329, equated the three terms incident, event, and occurrence. And of course, your lordships have been told about, and indeed know about, AXA and Field and Lord Mustill. This is also the ordinary way in which we use these words, as to refer to something inherently particular and confined. And as the Hiscox Action Group say, and I gratefully adopt their submission, the word occurrence is different from abstract, widespread concepts like danger or emergency. They don't say that. What they do say in paragraph 39.1 is that occurrence is, quote, typically contrasted with a general state of affairs, close quote, like a pandemic. Read without hindsight and in context, it would not naturally be construed as applying to national states of affairs. Now, the clause at 1560, C22 1560, does not refer to an outbreak. it refers to a notifiable human disease. On the previous page, the definition of a notifiable human disease is a disease, an outbreak of which must be reported to the local authority. But that doesn't advance the FCA's position. It's just describing what it is that has to be reported, what a notifiable disease consists of. And anyway, of course, a single instance of Legionnaire's disease is an outbreak. The judgment below, my lords, provides some support from the submissions I'm making, because it was the very absence of the word occurrence in the Amlin clauses that assisted the court to hold that disease generally was covered there, not just local disease. That's judgment paragraph 196. And it is implicit that the converse is also true. Sixthly, my lords, while there is no conceptual difference between a 1 mile radius and a 25-mile radius, the former is in practice a pointer towards the Hiscox parties intending to confine the occurrence to those of a strongly local character. The area is just over 3 miles. Even I can work that out. The court below expressly recognised the force of this point in relation to QBE3, which it held did not provide pandemic cover for this reason, among others. 1 mile is not just a lot less than 25 miles, it's a clue to a different contractual intention. That's judgment paragraph 237. It's simply not possible to regard this stipulation as merely adjectival, and the court there didn't. Seventhly, my lords, many Hiscox policies, including that at C22-1558, have a non-damage denial of access clause. May we look at it, please, 1559. This also has a 1 mile radius stipulation. An incident, if the lordships have it, within a 1 mile radius which results in the imposition of certain restrictions. Now, the court below held that this clause was confined to small-scale local events and did not cover something as geographically dispersed, variegated, and non-specific as the pandemic, judgment 405. If I had time, I would read to your lordships paragraphs 404 to 407 and ask your lordships to read them. It is prima facie surprising that 2 identical radii in clauses both about restrictions imposed on premises by authorities on adjacent pages of the same contract should be held to serve such diametrically opposed purposes. Eighthly, my lord, the word within occurs before the 1 mile stipulation on page 1560. As if your lordships have been told before, within more naturally denotes that the incident must be within the circle and not outside it, as in within these 4 walls, or the premises will be supervised within the hours of daylight. But your lordships don't have to take my word for that. That is the meaning which the court gave the word within in Hiscox's NDDA clause. If your lordships look, and again, I had to take your lordships, ask your lordships to do this, your lordships will see the submission at paragraph 399, and the only way in which one can read the judgment, paragraphs 405 and 406, is that that submission, namely that within could only mean within and not outside, was accepted. Surely the preposition within should have the same meaning in both clauses. The only answer to these points are in the, if I may say so, uncharacteristically weak paragraph 312 of my learned friend's Respondents' case. And they really stack up to no more than, well, if that's what you meant, why didn't you make it clearer? Not a submission which your lordships presumably are often troubled with. Cases that come to the Supreme Court by definition haven't made them clearer. Now, so those are the 8 points I want to make on, as it were, on construction. But there are others. Why is the requirement for close proximity inserted? The obvious purpose, as others have submitted, is to ensure that only local events are covered. If the cover is intended to respond in the event of a national pandemic, why have the parties stipulated for a radius at all? What's it for? The court's construction has everything turned on whether a sufferer adventitiously happens to encroach within the circle. So the critical element of the cover, constituted by the radius, is reduced to an adjectival precondition before the assured can recover an indemnity for all the loss caused by the pandemic. In a moment of candour, the Hiscox Action Group at paragraph 30 say, or concede, they don't use that word, this may seem harsh. I suppose they mean harsh to a loser in the postcode lottery, that the court has construed this clause as creating. Well, they may say harsh, your lordships may think completely arbitrary is a better description. And if we look at the FCA's case, we'll look at this, B10-390, the FCA's Respondents case 184. The FCA says, as if it were the law of the Medes and the Persians, in this paragraph, last two sentences, an epidemic is covered, but only if the premises are sufficiently close to it. A remote-only epidemic is not covered. Now, what sense does that make? My learned friend, Mr. Edelman, in paragraph 261 of his Respondents case, deflects this problem in saying that the examples involving trawlers and aeroplanes are, quote, fantastical, unquote. They're not. My learned friend, Mr. Keeley, alluded under a thin disguise, which I'm sure your lordships penetrated, to the peregrinations of a notorious COVID-suffering Scottish Member of Parliament. For Hiscox 4 policyholders, the vast majority of whom, by the way, do not live anywhere near the Royal Courts of Justice, everything depends upon whether they happen to have a house near the London to Edinburgh line. Now, we say, and we have a finding in our favour on this, the government measures in March were self-evidently not in any sense caused by an occurrence of disease within 1 mile of an insured's premises. And if we look at judgment paragraph 418 at C3149, we can see that this finding is specifically made in respect of Hiscox's NDDA clause, even assuming that a person with COVID within the radius could be described as an incident, which the court has said it couldn't. So the court here says the position under the FCA alternative case is no better as regards causation, even if the presence of a person with COVID within the radius or in the vicinity could be said to be an incident, which it cannot, for the reasons we have given. It simply cannot be said that any such localized incident of the disease caused the imposition by the government of the restrictions. So where does one go from here? Well, the answer is this. Unless the occurrence in Hiscox 4 is construed broadly enough to include the whole pandemic, an occurrence within 1 mile means the whole, or includes the whole pandemic, it necessarily follows that the FCA cannot prove the recognised causal connection required between the stipulated occurrence and the restrictions imposed. My lords, I see the time. I have a little more on this point, but I don't think I can necessarily complete it in 3 minutes, although I probably could complete it in a few more than 3 minutes. I'm in your lordship's hands.
Well, shall we adjourn then for 5 minutes, and then we'll hear you further in 5 minutes' time. Thank you very much. Yes, Mr. Gaisman.
My Lords, there is no appeal by the FCA in relation to paragraph 418 of the judgment. And so, as I say, unless the occurrence is construed broadly enough to include the entire pandemic, it necessarily follows that the FCA cannot prove the required causal connection. Now, we need to look at the one paragraph of the judgment on this, paragraph 273 at C3113. And we respectfully criticise the following aspects of this judgment. First, in saying in line 3 that official responses would likely be to the full extent of an outbreak, the court was with respect begging the key question whether a clause in the terms of Hiscox 4 was intended to respond to an outbreak beyond 1 mile. My Lords, the only stipulated occurrence here is an occurrence of disease within 1 mile, and that has to be a cause of the restrictions. In paragraph 272, as regards Hiscox 1 to 3, the court recognised that that requires a causal connection between the occurrence and the government measures, or whatever it happens to be. However, in 273, it does not. As regards the stipulated occurrence, i.e. the local occurrence, following means only temporally posterior. That's the language used. This was because the court treated the local occurrence as part of the national outbreak. This is the court's part of an indivisible cause reasoning, which Mr. Salzido and others have criticised. For my part, I would only ask, indivisible for what purpose? Because, as Lord Hoffman says, the proper formulation of a value judgment depends on the purpose for which the judgment is being made. It's no good, the FCA's Respondents case 356, saying that common sense dictates an inextricable linkage. Paragraph 356 feels the need to invoke common sense 3 times in 8 lines, 3 times within 8 lines, in fact. As Lord Hoffman said in his Chancery Bar lecture, this appeal is a rhetorical device to divert attention from the absence of reasoning. But going back to Lord Hoffman in his judicial capacity, you have to ask, for what purpose am I asking the question? Now here, the contractual context is all important, and the question that the parties require to be answered is whether the stipulated occurrence has caused the restrictions imposed. Extrication of the stipulated occurrence from the pandemic to the limited extent necessary to answer that question is easy. The court did it in paragraph 418. And the answer is they found no causal connection. But the exercise is necessary under the contract for this reason. I'm sorry to fall back on quasi-algebra. Where the contract requires one to decide whether X caused A, you do not ask whether X is part of Y and whether Y caused A. That's the wrong question. So what's gone wrong here is that the requirement of causation has been transferred to the national disease. And the result is not only a very convoluted reading of a simple clause, but, if I may borrow back Mr. Keeley's filching of a phrase in our mutual discussions, what is covered but not causative has been conflated with what is causative but not covered. Now, I've shown your lordship the Hiscox NDDA clause, and I've shown your lordships the causation analysis. We do make the point that it is most peculiar for the causation analyses within these 2 similar clauses with the same limit, nearly adjacent in the contract, to have such radically different outcomes. And this must have happened in our respectful submission because, with respect, the court's approach has been influenced by hindsight. Before February 2020, the parties will have been familiar with local authorities closing down premises because of rats or bad drains. And what has happened is that the court has squeezed in the unprecedented events of this year, despite the fact that there are clear indications in this clause but that is not what these parties objectively intended. My Lord, that's all I want to say about Hiscox 4, and I want now to turn to grounds 1 to 4 of our appeal, causation and the counterfactual under all the Hiscox clauses, assuming that the cover is triggered. I now assume that a complete peril exists. And the question, when we talk about causation here, we're talking about the relationship between the completed peril and the loss. And it's in that context that the counterfactual questions arise. My Lords, we don't need to spend any time on the principles. The court below unequivocally applied a but-for analysis in Hiscox's case at judgment 278, quite rightly. It's agreed that the question is not what the principles are, but how they should be applied. As my learned friend Mr. Edelman says in paragraph 9 of his respondent's case, the question is not whether but for what? And our answer is that the principles should be applied in the same way as in any other case. The correct approach to the measure of indemnity under the PA clause in the Hiscox policies involves two inquiries. First, analysing the nature of the insured peril. Secondly, in the light of that analysis, constructing the correct counterfactual and comparing that with the situation which the insured is in, and the difference is the measure of indemnity. My Lords, the counterfactual is the mirror image of the insured peril. And we find ourselves in complete agreement with the Hiscox Action Group, footnote 15, who say that the role of the counterfactual is entirely dictated by the express terms of the policy. It is the insured peril, as Mr. Keeley submitted to your lordships, that is reversed out in the counterfactual, no more, no less. The authority for that proposition is Orient Express, judgment paragraphs 46 to 47 and 51 to 52. And while I'm on the Orient Express, just two other points. As my learned friend Mr. Keeley showed your lordships yesterday, there is no rule that one must reject a counterfactual if it is artificial. It is by definition a purely hypothetical construct. And again, Orient Express clearly stands for that proposition. What could be more artificial than an undamaged hotel in a devastated city? Yet the court below expressly declined to accept our counterfactual on the grounds of artificiality, judgment 279, thereby adopting precisely the argument that my Lord Hamlin rejected in the Orient Express at paragraphs 46 and 47 of the judgment. I should also mention, sorry to be straying off topic, that the Orient Express directly contradicts the FCA's argument, that's made at some length, that trends clauses are confined to purely extraneous events which have no connection with the insured peril. The paragraphs of the judgment in the Orient Express 48 and 57. So I turn then to the public authority clause, and if we can have it on the screen again, C6401. And look at this in more detail. It's a fundamental point, my lords, that this clause does not insure against business interruption caused by vermin, disease, drains, etc. In the ABCD taxonomy adopted in our appellant's case, which I hope your lordships have in mind, it is not insurance against A causing D. It's odd then that the Hiscox Action Group complains that our construction, impermissibly it says, is we will not cover you caused by X alone, where X is rats, drains, disease. What's wrong with our saying that? We're back to the 13th chime point in the FCA's case, which, by the way, is repeated in their respondent's case at paragraph 454. Now, the FCA, when it acknowledges that public authority restrictions imposed are an essential element of the peril, as we have seen, treats that element as purely adjectival. It's treated like the radius in the disease clauses. Well, my lord, one is tempted to rebut that by saying just read the clause. The FCA's Respondents case at 388 and 389 seeks to justify this approach by saying that the underlying emergency will predate the public authority action, and it must be contemplated that the former could cause loss of its own. Well, 2 points as to that. First, as previously submitted, contemplation of an eventuality does not imply an intent to cover it. But secondly, this is where the FCA's confusion of Hiscox's clause with the express emergency clauses that, for example, Arch has, is so unfortunate. In the case of the Hiscox clause, there is no necessary emerging peril or emergency at all. The whole thing may occur at the same time, with the baleful knock at the door of the restaurant by the environmental health officer on a routine visit. In the typical case, it will be the public authority action which causes the loss. Now, 2 features stand out in this public authority clause, which is on your screens, I hope. And we can take these 2 features quickly because they're common ground. First, this is a composite peril consisting of several elements which must all be present. Secondly, mere presence of these elements is not enough. It is not a case of ticking all the boxes, as the Hiscox Action Group says, paragraph 15 of its appeal case. The elements are arranged in a particular causal combination. The FCA agrees with that. Now, these 2 features have 3 consequences, and this is where we part company. First, until you have A causing B, causing C, causing D, the insured peril has not occurred. Now, the FCA agrees with that. The second step is the crucial one. We submit that it follows from the first that only in respect of loss caused by the elements acting in that causal combination can there be a breach of contract, namely the insurer's failure to hold the insured harmless against that combination causing loss. That must follow from the premises so far that this is where the FCA has to disagree or the game is up. But it's wrong. Therefore, thirdly, for the purposes of the counterfactual, it is that causal combination and that loss alone which one reverses out. Now, loss caused by A, X, C, D is not covered loss, and it's not reversed out in the counterfactual. That is what happened in the Orient Express. What was covered there was damage to the hotel, causing interruption, causing loss. Let us call that B, C, D. Even if the court below were right that the hurricane in Orient Express was somehow part of the peril, that gives us A, B, C, D. It still does not mean that loss sustained due to damage elsewhere in New Orleans is covered, because that would be A, X, C, D. Likewise here, loss caused by the consequences of COVID not amounting to restrictions imposed is not covered, whatever that is. The next point is this. Although the insured peril is composite and has several elements, it is not axiomatic that each element has equal weight. Whether this is so, or whether the clause has a predominating element, is a matter of construction. It matters because identifying the core of the insured peril demonstrates the scope of the indemnity and the appropriate counterfactual. If the public authority action is the centre of gravity of the clause, it must be fallacious for the FCA to say at its 13th chime point that the parties intended that the insured recover for losses that would have been incurred even without the public authority restrictions. Now, the FCA in substance agrees that searching for the essence of the peril is the right sort of question. It just gives a different answer. As I said, it originally called the clause a disease clause, which was pure question begging. But its case is, and the references are in our appeal case, paragraph 37, its case is that the essence of this clause is an insurance against rats drains, etc. That is what it calls the insured event. I'm quoting from its skeleton below. As I say, I've given your lordship the reference. And they say that the purpose of that condition, sorry, that's the insured event. They say the public authority action is simply a condition that has to be fulfilled to trigger cover, the cover being cover for rats, drains. And they say the purpose of that condition, it's in the same paragraph, is to ensure, one, that cover is only triggered by serious case of rats, and secondly, to enable the insured to prove its claim. And look, we say this is not difficult. This is not a case of insurance against rats, provided only that there's public authority action. It's an insurance against the stated consequences of public authority action, provided that the reason is one of the things enumerated in clauses A to E. Now, we deal with this in our appellant case, paragraph 34, which I have to take as read, but one can test the matter in this way. If we can go back to the clause itself, that's a reference, C6401, thank you. One can test the matter in this way. These subclauses A to E make clear that not all restrictions imposed by public authorities will trigger cover, but only those imposed for the reasons identified. If those clauses were not, the subclauses were not present, there could be no doubt that the maximum ambit of the indemnity was for the consequences of restrictions imposed. But A to E qualify the public authority action which is within the cover. They circumscribe the insured peril, making clear that it only responds to a subset of all possible causes of restrictions imposed. The presence of these limitations, therefore, cannot have the effect of expanding the peril or changing its character. And since disease is not a peril in its own right, but rather its presence in the clause identifies the type of restrictions imposed, it cannot be right, in principle, to require Hiscox to indemnify the insureds for all losses flowing from it as if it was the independent peril, which it isn't. So the FCA's construction turns the clause on its head in the way and for the reasons I have indicated. Now, what happened below? The first thing that happened in the court below, my lords, is that we made these submissions and the court did not address them. And we would respectfully submit that that was the court's first mistake. And it led to its second, which was to analyse the peril as one which merely required the presence of the constituent elements, rather than loss flowing from their causal combination. That error is explicit in the penultimate sentence of judgment paragraph 278, C3114, where one has, a few lines up, what the insured is covering itself against, we consider, is the fortuity of being in a situation in which all those elements are present. And both of those, so in other words, in our probably rather tiresome illustrations, the court treated it as a case of adjacent tiles rather than superimposed tiles. Both of those errors, my lords, led to the third error, which is a supposition that the clause requires the stripping out of the outbreak of COVID, the epidemic of COVID in its entirety. That cannot be right for reasons I've already indicated, because COVID is not the insured peril and Hiscox is not in breach of contract as regards the consequences of COVID, but only, to simplify the peril for the sake of clarity, in respect of loss caused by public authority restrictions consequent upon COVID. We never promised to hold the insureds harmless for all loss flowing from the first element in the causal chain. So how can that be the measure of damages for our breach of contract? In other words, the public authority restrictions are like the damage requirement to the hotel in the Orient Express. They act as a filter, which make clear that it is not necessarily all the loss flowing from the underlying cause which is covered, but only some of it. How much will depend on the facts. The court's fourth error, my lords, was to think that our analysis wrongly leaves the disease in the counterfactual and therefore fails to recognise that the disease is an essential element. That was the court's reasoning at 279. But we recognise that the disease is a necessary element, but it is not the predominating element, as I have indicated. My learned friend and I disagree about that. And we do strip it out of the counterfactual, but only to the extent that it causes restrictions imposed. Now, I'll come back, time permitting, but I think it should permit, to the games with which the FCA plays with this submission in paragraphs 431 to 433 of its respondent's case. But I'll do that in a minute, if I may. The fifth error of the court below was to move away from contractual construction to supposed problems of proof. And I need to spend a little time on this, which were said to arise on Hiscox's construction, because that's what the court did in paragraphs 280 to 282. Now, this is actually rather a bold thing to do, to fashion a counterfactual which is not the mirror image of the insured peril, which it should be, because otherwise the cover is, quote, illusory, close quote, from the insured's point of view. What was the evidence that that was so on Hiscox's construction? My lords, there was none. There is none. It's just the FCA's say-so. Moreover, as far as the court was concerned, on an extreme and doubly contrived example of a restaurant, the sort of business with, by the way, 95% of Hiscox's policyholders have nothing to do with. A restaurant, one, overrun by rats, two, through no fault of the owner, your lordships remember they've migrated from a nearby building site, and three, which is first voluntarily closed and then compulsory closed, a special feature of my learned friend's example deliberately included in order to obscure an otherwise apparent trend. Now, let me spend a little more time on these supposed difficulties of loss. What the court has done, without any evidence or concrete foundation, to ascribe to the parties a distinct prospective intention to abdicate any attempt to work out what loss was caused by the actual insured peril and what loss would have occurred anyway, on the basis that they must have assumed in advance that the problem of quantification of loss would be so difficult in a business interruption insurance of all things, that the normal rules governing the measure of indemnity should be discarded. There is no basis for this. My learned friend for the Financial Conduct Authority asserts without any grounding that proof of the losses caused by the public authority restrictions is impossible. It's a word he uses many times. For example, Respondents case 459. Not only is that not evidence, it's wrong. Now, this is important. The account, could we look at it, please, in the FCA's Respondents case 450, B10475. The account of how loss adjusting would take place in the present circumstances is one that Hiscox simply does not reckon. It bears no relation to reality, and I will demonstrate this with a simple case. A restaurant is ordered to close on the 21st of March. It reopens on the first available day in early July. The FCA's question is, how can you tell what part of the loss during the lockdown is due to public authority closure and how much to the other effects of COVID, assuming no closure? You can't, it says. So the restaurateur should have 100% of his loss. The court agreed. Now, the obvious metric that the loss adjuster in that example would no doubt propose is this. Look at its performance before it was made to close. Look at its performance after it was allowed to reopen. What is the problem with treating those numbers as a good approximation of the loss caused by COVID, as opposed to the loss caused by the enforced closure. Now, we are not after perfection here, my lords. The trends clauses in the Hiscox policies and many others just say that the ascertainment of the position has to be, quote, as near as possible, close quote, to the position had the peril not occurred. There's no difficulty here, my lord. May I tell your lordships what the difficulty is? The difficulty is in understanding how the FCA can say that a business whose turnover went down to 30% of normal in March and was 25% of normal when it was allowed to reopen in July, can claim 100% of its normal turnover in between the two, on the grounds of some supposed impossibility of extricating the effect of closure and the effect of COVID at large. My lords, that is the complete answer to this whole area of the FCA's case. And no doubt we will hear from my learned friend his explanation for why it is that he has apparently seriously told your lordships that his estimate is that the claimant's loss adjuster would have to, or the claimant's expert, would have to produce a 2,000-page report to prove loss. That's paragraph 454. And he'll no doubt explain why the sort of approach I have outlined, which is, well, there's no evidence in this case, my lord, on either side. So there are two answers to this paragraph 450 point. First, stripping out all the effects of COVID after the peril is triggered will clearly over-indemnify the insured. And secondly, the supposed inextricability does not exist. Then, my lord, my learned friend, on a bit of a roll, paragraph 454, invites the supposition that each small or medium-sized enterprise insured with a low limit will have to retain its own loss adjuster and presumably its own expert producing that 2,000-page report. That is also unrealistic. All the Hiscox policies in this case contain arbitration clauses. And I can tell your lordships, because the Hiscox Action Group have chosen to put this into the public domain in a press release, the fact that Hiscox has agreed to consolidate the members of the Action Group's 384 individual claims before a single panel of 3 arbitrators reviewing 4 categories of policy. It's also the case, of course, that the Financial Ombudsman Service will also no doubt hear claims, and he has, or she, whoever it is, has jurisdiction to take a rough and ready approach based, and I'm quoting from FISMA section 228, what is fair and reasonable in all the circumstances of the case. And no doubt with low aggregate limits, that's exactly what everybody would expect. So this, in the circumstances of this pandemic, taking my learned friend's favourite example of a restaurant, where's the difficulty? Where's the insuperable difficulty? Where's the difficulty that's so great that the parties have torn up the rule book when it comes to constructing the counterfactual? Now, what then happened below, and luckily I haven't got time to go into this a great deal, is that the parties traded. Your lordships will have seen this from the case. Cases involving food poisoning and cases involving rats. Something rather unkind is said about our food poisoning example. I must rise, I think, to this fly at least. It's paragraph 392.3 of my learned friend's case, where he says that my example of somebody who's food poisoned and complains to the authorities who closed down the restaurant, where's the problem with the loss being caused by the closing down? That example is criticised on the basis that I have dodged, it's my learned friend's word, rather unkind, dodged the case of the customer complaining to the restaurant. No, I haven't. let the customer complain to the restaurant. Let the owner of the restaurant report himself to the local authority. He's hardly likely to close himself down voluntarily when one person has complained of food poisoning in his restaurant. But let the authority close him down. That has to happen even on my learned friend Mr. Edelman's case. All the loss of trade will typically be caused by the closure. And if the disgruntled customer has gone on social media a week before the closure to publicise the episode, any resulting downturn may be brought into the calculation, which is exactly consistent with the part of the judgment that my learned friend Mr. Edelman does not like, namely the conclusion that the court reached in relation to the pre-trigger downturn, where it held that it was legitimate to take into account the depressing effect of the gathering storm, or in this case, Twitter storm. There is nothing wrong, my lord, with a Hiscox citing example where the underlying cause would not have affected the business, such as Legionnaire's disease or a suicide or a local measles outbreak. My learned friend recognises that in these cases there would be no difficulty in the insured proving his loss. So what he says is that these are, quote, outlying cases. That's paragraph 393. Well, my lord, I'm sorry, but who says? This is pure assertion, as so much of this section of my learned friend Mr. Edelman's case is. Then we get the rat example, which apparently impressed the court. Now, if we can get away from contrivances involving building sites, there are two possibilities here. Either the rats or the cockroaches or the mice are in the kitchen and customers don't know about it. Well, the occult rat problem will lead in casu to closure by the public authorities. No problem in the insured proving his loss. Or, the alternative, the rat problem is known to customers. Amazingly, the rats are in the public areas of the restaurant. In this case, it's not unreasonable to suppose that the natural human antipathy to rats will depress turnover before the public authority closure. And that decline would provide an approximation of the effect of rats without public authority closure, thereby enabling the insured to prove the additional effect of the public authority action. Lord, if I had time, I would say other things about my learned friend's examples, but just as it were summarising here, and then I've got only one or two further areas I just need to deal with. The court was over-impressed by the supposed difficulties of proof, which were an important part of its reasoning in paragraph 281. My learned friend, encouraged by that, keeps saying that modelling and proof remain impossible, but there's no evidence of it. Of course, he helpfully also reminds us that Lord Mance, in his book on insurance disputes, says that intangibles and hypotheticals are the very stuff of business interruption insurance. He cites that in his appellant's case, paragraph 6, and there's no getting away from that. And the last point here, perhaps, well, almost the last point, is that this all presupposes that the burden is on the insured. That's expressly assumed in judgment paragraph 281, despite the fact that we expressly recognise below that although it will depend on the facts, once the elements of the clause have found to be proven and loss has prima facie been shown to result, the evidential burden may in a given case shift to the insurer to prove that the loss would have occurred anyway. And only friend paragraph 459 of his respondent's case contains no answer. Fortunately, I have no time to waste on the silver cloud, a decision which the court below rightly regarded as a case on its own fact. And really, the exercise of crowbarring, the finding of inextricability on the facts of that case into the facts of this one, goes well beyond the legitimate use of authority. My lord, all I need to do now is just deal with my learned friend's, as it were, teasing points on our counterfactual in paragraphs 431 to 433. Shorn of rhetoric, he raises two questions. First, what does Hiscox mean by taking out disease insofar as it causes restrictions imposed? And secondly, which restrictions imposed are taken out for the purposes of the counterfactual? the answer, I'll deal with the first point first. In the PA clause, the restrictions must follow, i.e. be caused by, in some sense, the disease, and then the restrictions must cause inability. So as far as the insured peril is concerned, it is the causal effect of the disease which is covered and nothing else. That causal effect is the function of the disease in the clause. Restrictions not caused by A to E are not covered. The disease, therefore, needs to be removed insofar as it causes the restrictions imposed. That's not the same as removing the whole pandemic, whatever paragraph 433.3 says. And if my learned friend reminds himself of paragraph 421, he will see that in relation to Arch, he recognises that that's not the effect of the argument. Equally, and more importantly perhaps, contrary to 433.1, this does not involve working out what lower level of disease might have been just sufficient to cause relevant restrictions. Nothing as complicated as that. With great respect, my learned friend is making complications which don't exist. It arises because my learned friend misunderstands our use of the expression insofar as, and implies that we're using the expression quantitatively when we are using it causatively. A similar point is in 433.5. Lastly, my lords, restrictions. What restrictions are stripped out of the counterfactual? The restrictions imposed, which are relevant and insured, are those which produce an inability to use the insured's premises. Any other restrictions imposed are irrelevant to the insured peril. Taking the 26th of March regulations, regulations 4 and 5 are capable of being restrictions imposed. Now, you'll have the example of something called a nail salon, which was ordered to close by Regulation 4 and Schedule 2, Part 2. For a nail salon, the relevant restriction is Regulation 4. It's not the whole of the regulations. It's not the other regulations. They are not a restriction imposed relevant to the nail bar. Regulation 4 applies to all nail bars. Unlike the usual case of rats or drains, this is not a case of a restriction aimed at a single premises. The restriction applies to all premises of a certain type. So that restriction, which gives rise to an inability to use the insured's premises, is the one that is removed for the counterfactual. That means you don't remove the entire regulations, contrary to FCA 432 and 433.4. You don't assume in the counterfactual that the insured's nail bar is the only nail bar open, because the restriction applies to all nail bars, contra FCA 432.2. Therefore, in the counterfactual, all nail bars are open, and there is no question of windfall profits, contra FCA 433.3. Now, in this part of the case, the FCA seeks to set up hard questions for the loss adjuster, but it is simply a question of the court or tribunal deciding what, as a matter of construction, is the relevant restriction imposed. The possibility of argument about what the relevant restriction imposed is a legal argument that does not help the FCA's case. In any case such as this one, there can be debate about the ambit, as a matter of law, of the insured peril. Accordingly, the possibility of debate over the ambit of the insured peril exposes no conceptual flaw in our analysis. If there is a dispute in any given case, the legal tribunal will decide what are the relevant restrictions imposed, and the loss adjuster will then deal with the consequences. My lord, those are my submissions, unless I can help the lordship any further.
Thank you very much, Mr. Gaisman. We now turn to the last of the counsel on behalf of the insurers, Mr. Lockie, Queen's Counsel, for Arch Insurance. Mr. Lockie.
My lords, good morning. Arch's appeal raises issues of causation at the stage of the quantification of loss, where a prevention of access business interruption extension has been triggered. In the taxonomy used in this litigation, Arch is not a disease clause insurer nor a hybrid clause insurer. It's a prevention of access insurer. the relevant Arch policy contains a number of non-damage business interruption extensions, only one of which is relevant for these proceedings, the Government and Local Authority Action Clause, or GLAA, extension 7, which your lordships will find at C tab 4, starting at page 226. At 226 on the right-hand side, you'll see under the heading Clauses, you'll see the STEM language, which refers to and introduces the individual non-damage business interruption extensions, and you will note the language used resulting from at the end of the first, at the end of the introductory words, before Clause 1, prevention of access. We can ignore 1 and 2, and we can skip over 3, the disease clause. Extension 3 does not apply in the present case because there was a closed list of notifiable diseases in the Arch policy, which did not include COVID-19. So we could ignore Clause 3 for present purposes, although its terms may be of relevance on the FCA's appeal on ground 3, and we can look at that in due course if we have to. So if we turn the page to 227, your lordships will find at 7 the relevant clause, the Government and Local Authority Action Clause, and obviously the focus is upon the first 3 lines. And it is clear, we would respectfully suggest from its terms, that it's not every prevention of access to the premises which will trigger this extension. To qualify, there must be a prevention of access to the premises, which is the result of government or local authority action or advice, which in turn is the result of an emergency of the requisite type. And the required sequence is set out in the clause itself. And if my lords turn back to pages 224 and 225 in C tab 4, the policy contains provisions for the calculation of the indemnity for business interruption losses, and it's common ground that these apply to the non-damage extensions as well as to the standard business interruption cover, which applies where there has been damage to property, with the word damage with a capital D replaced throughout with the language of the relevant insured peril under the non-damage business interruption extensions. And we explain these provisions in our written case at paragraphs 13 to 25, and I don't have time to develop those points orally. The key provisions are the indemnity in respect of the loss of gross profit, which you will see on 225 at the top of the right-hand column. The amount payable will be in respect to reduction in turnover, the sum produced by applying the rate of gross profit, the amounts by which, due to the damage, the standard turnover exceeds the turnover during the indemnity period. And then, if one turns back to 224, at the foot of 224 in the right-hand column, we have the Arch trends language, the trends clause under the definition of standard turnover, and I just ask you to note the terms of the Arch trends clause there set out, and it continues at the top of 225 in the left-hand corner, closing with the words, the adjusted figures will represent as near as possible the results which would have been achieved during the same period had the damage not occurred. Now, my lords, Arch's position as to when and in what circumstances the GLAA clause was triggered was accepted by the court at paragraphs 309 to 336 of the judgment. I'm not going to ask you to look at that. You will no doubt read and reread that in due course. That position is reflected in the order made following the trial. I'm not sure that anyone has actually referred your lordship specifically to this document. Obviously, it's it forms the heart of the appeal, the declarations which were made following the trial, and it's C tab 1, and if you look at pages 8 and 9, at paragraphs 14.4 and 14.5, you will see the so far as the trigger of coverage under the Arch policy is concerned, that the position was set out in paragraphs 14.4 and 14.5, essentially as Arch had argued in the court below. And in short, and summarising what is set out in 14.4 and 14.5, and more generally in paragraphs 309 to 336 of the judgment, the court held that there was a qualifying prevention of access to the premises only for those businesses who were advised or required to close their premises by the government in late March 2020 as a response to the pandemic, the emergency, for the purposes of the GLAA clause. And that was the position which Arch had already taken in its dealings with its policyholders. Arch has accepted throughout that for certain classes of business, the GLAA extension has been triggered, and the issue has been one of quantification. And Arch's appeal raises an issue of causation, or issues of causation, in that context, where the policy has been triggered. Now, my lords, in those paragraphs of the judgment which deal with policy trigger, the court held correctly that the pandemic, the emergency in the GLAA extension, was not the insured peril. That's paragraph 309. And at paragraphs 328 and 329 of the judgment, the court also held, again we say correctly, that the social distancing advice and regulation 6 of the 26th of March 2020 regulations, the direction that people were to stay at home unless they had a reasonable excuse for leaving, those regulations and that advice did not prevent access to insured premises for the purposes of the GLAA extension. And that conclusion is reflected in paragraph 14.5b of the declarations. And so the key issue on Arch's appeal is whether, in adjusting claims where there has been a relevant prevention of access, Arch can seek to remove loss which the business would have suffered in any event by reason of the emergency and its economic consequences, even if the premises had not been required to close. And the court below ruled this out as a matter of law, and it is this which our appeal challenges. The FCA's written case on its appeal acknowledges at paragraph 7.1, and the reference is B tab 2, page 30, that many businesses may have suffered a reduction in turnover because of the emergency during the period after the policy was triggered, even if there had been no closure, advice, or requirement. And we would say that in those circumstances, it follows that it was not the prevention of access which caused that particular reduction in turnover. But the court's judgment means that that reduction in turnover is recoverable. And we respectfully submit that something has obviously gone wrong with the court's analysis. And that is because the GLAA clause clearly does not provide an indemnity for those losses which a business would have suffered even without the prevention of access. Now, my lords, we of course all have sympathy for those running businesses, particularly small and medium-sized businesses, which have been severely impacted by the effects of COVID-19. But an expansionist approach to the construction of insurance clauses and to causation is not, we would submit, an appropriate or principled solution, nor is it one which is likely to be satisfactory in the long run. And ultimately, the question of what cover has been granted is dictated by the terms of the policy and not by reference to what may or may not have been reasonably foreseeable. My lords, the FCA makes the point in its written case that the GLAA extension contemplates the existence of an emergency which could have many effects for a business beyond prompting government action which causes the prevention of access to the premises. And that may well be right. But that does not mean that one should read the policy as if it said that all the effects of the emergency will be insured if access to the premises is prevented by government action taken in response to the emergency. And we would respectfully submit that the policy clearly provides that it's the economic effects on the business of the prevention of access to the premises which are covered, not the economic effects on the business of the emergency in the round. And the effect of the court's judgment, and I'll show you the relevant declarations in a moment, is that Arch is prevented from seeking to adjust claims on the basis that some or all of its policyholders would not have realised all or some of their expected gross profit, even if the premises had not been closed, and that those businesses would have suffered a loss of gross profit in any event, even if they had remained open, because of the economic effects of the pandemic, including the reductions in footfall caused by Regulation 6, the instruction to stay at home, and the social distancing guidelines, and other matters such as the general lack of consumer confidence and the economic recession brought about by the pandemic, none of which are insured perils. And if you've still got the declarations order open, my lords, can I just direct your attention to the particular declarations of concern in this context? Declarations 11.1 and 11.2, and in particular 11.2b for the Arch clause. These declarations prevent Arch from arguing...
I'm sorry, could you remind us of the bundle and page number?
I am sorry, my lord. It's
not at all.
Bundle C, tab 1, page 6.
Thank you very much.
Paragraphs, declarations 11.1 and 11.2b. And my lords, those declarations prevent Arch from arguing by reference to the turnover in fact achieved by a relevant insured business in the months following the reopening of their premises, when the business continued to be affected by the emergency and its economic consequences, that the gross profit during the period of closure would have been lower than the gross profit achieved over the same period in 2019, even if the premises had remained open, because of the wider effects of the emergency. And declarations 11.2, 11.1 and 11.2b also rule out as a matter of law Arch's ability to point to evidence that businesses which were not required to close their premises from late March until early July 2020 suffered a reduction in turnover compared to the same period in 2019 because of the economic effects of the pandemic and the reduction in consumer footfall as a result of the emergency or the stay-at-home advice and Regulation 6. We managed to salvage something on causation below in Declaration 11.4c, which is the subject of ground 1 of the FCA's appeal, the pre-insured peril downturn point. But Declaration 11.4d, qualifying 11.4c, precludes Arch from arguing or showing that a pre-peril downward trend in turnover due to the emergency would have accelerated during April, May and June 2020, even if the premises had not been required to close. So, my lords, one asks, perhaps rhetorically, how did the court fall into error? And in our respectful submission, it is an error in construing the GNAA clause. The court's judgment on the quantification issue starts at paragraph 337 in C tab 3 at page 129. And the court's main conclusions, so far as Arch is concerned, are at paragraphs 345 through to 348. Now, my lords, the court did not set out the policy provisions for the calculation of an indemnity, and they proceeded instead, as you will see, from 337. The court proceeded straight from dealing with which policies were triggered for which categories of business to the trends provision. They proceeded straight from examining the question of coverage to an analysis of the trends clause, and the court appears, at least in this part of the judgment, to have concluded that the requirement for but-for causation, and as I said, we're here concerned with quantification and not with whether the peril has operated. We're here concerned with the quantification. The court appears to have concluded that the requirement for but-for causation arose because of the trends clause and not otherwise. Now, my lords, I accept that the point may be academic because we do have a trends clause, but we do submit that the court below was in error if, as appears to be the case, it assumed that the requirement for but-for causation only arose because of the presence of the trends clause. And we would submit that even in the absence of a trends clause, a policyholder whose premises have been closed because of government action is not entitled to claim a loss of gross profit, which the policyholder would not have made if the premises had remained open. But be that as it may, the trends clause is present in the Arch policy, and the FCA accepted, and the court found, that it mandates the application of a but-for test of causation at the quantification stage. At paragraph 347, the judgment, C tab 3, page 132, the court held that the comparison required was with the hypothetical performance of the business as if there had been no emergency and thus no government actions or advice, including the social distancing advice and regulation 6, and that in those circumstances that Arch's case should be rejected. Arch's case, in summary, was, and it remains, that the appropriate counterfactual involves assuming that the insured peril did not operate. And the assumption is therefore that the premises remained open and that the relevant part of the regulation requiring that category of business to close its premises is assumed not to have been made. And by the court's application of what it regarded as the but-for the insured peril test, what the court below has done has in fact treated the emergency as being an insured peril once the GLAA clause has been triggered. And that we would respectfully suggest is just wrong. The effect of the court's conclusion is to widen the indemnity in the GLAA clause from one which covers the consequences for the business of the access to the premises having been prevented to one which covers all the consequences for the business of the emergency during the period when the premises are required to be closed. And we say that that involves a substantial and impermissible rewriting of the GLAA clause. And we submit it's simply not possible to read the GLAA extension in the way in which the court read it. The court below appears to have concluded that each of the steps in the chain of causation set out in the GLAA clause takes effect as individual insured perils once the causal sequence is in place and the insured peril has operated. But that's simply not what the clause says. Labelling the clause as a composite peril, as the court did, does not improve the analysis. That label has no fixed legal consequences. And more generally, as a matter of general principle, there is no principle of insurance law or of contract law damages that requires the but-for counterfactual to assume not just the non-operation of the insured peril or the breach of contract, but also the absence of everything in the causal chain which leads to it. And the court does appear to have thought that there was a general principle to this effect, at least in insurance law. And I say this because of the court's reference to the insured peril in the Orient Express and the court's opinion that the cause of the damage in that case was, to quote, at paragraph 526, the judgment, perhaps I can ask you to look at that the cause of the damage in that case was an integral part of the insured peril. The last sentence of 526 and then 527. on the basis that the hurricanes were an integral part of the insured peril, we consider that when it came to the construction of the trends clause, the judge should have concluded that the words "had the damage not occurred" meant that the counterfactual was one where both the damage to the hotel and the hurricanes and their effect generally were to be stripped out. Well, we would respectfully submit that there is no principled basis for arriving at that conclusion, that the cause of the operation of an insured peril is to be stripped out as part of the counterfactual. So far as the Arch policy is concerned, if one turns back to 346 and 347 in the judgment, the court thought that the manipulated trends clause compelled the assumption that there was no emergency. And you will see this at paragraphs 346 and 347 of the judgment. At 346, the court set out, we've seen the policy itself at C tab 4, page 224, the trends clause, manipulated so as to incorporate in place of the words "the damage" the insured peril under the GLAA clause. And we have no beef with the exercise of manipulation which is there engaged in. But what the court then concludes in paragraph 347 is that it follows that upon the true construction of the Arch policy wording, the comparison requires the removal of everything, including the emergency. But with respect, it plainly does not follow. The unmanipulated trends clause in the ordinary case of accidental damage does not require an assumption that whatever has caused the damage to occur did not occur. And the position in this respect is identical, I would respectfully submit, to the analysis in the Orient Express case, and in particular at paragraph 46. The language of the manipulated trends clause likewise does not lead to the conclusion which the court reaches at 347. If one asks on the language of the manipulated trends clause, what is it that one assumes did not occur, it is simply the qualifying prevention of access. The plain language of the manipulated trends clause simply does not call for an assumption that the emergency has not occurred. Now, although the court does not say so in terms, the court does appear to have accepted that the trends clause only applies to matters which are unconnected to the insured peril. But no such limitations can be read into the Arch trends clause, or indeed any of the other trends clauses in this case. The Arch trends clause refers to any trends or circumstances, and the word "any" is hardly a promising start for a submission that there are limits on what may be a trend or circumstance. And we would respectfully point out that there's nothing in the language of the trends clause which says that something which is not an insured risk, but which is part of the causal chain which leads to the operation of the insured peril, cannot constitute a relevant trend or circumstance when it continues to have separate causal effect after the insured peril has operated. In other words, separate from its effect as part of the causal chain leading to the operation of the insured peril. Now, we have been treated, I use the word advisedly, we've been treated to an examination of the textbooks on business interruption insurance by the FCA. But there's nothing, when one looks at those extracts, there's nothing in those books which suggests that there is some rule that a trend or circumstance must be unconnected with whatever it is that has caused the peril. When the books refer to trends or circumstances as being something which is extraneous to the insured peril, the authors are making the obvious point that the insured peril is not itself a relevant trend or circumstance. and the authors are simply not addressing the issue which arises in the present case. My lords, finally, a word or two on inextricability and practicality. Can I invite your lordship's attention to paragraph 348 in the judgment below, see tab 3, page 132. My lords, the court was of the view that its conclusion on the counterfactual accorded with commercial and practical reality, and that there was an inextricable link between the various elements of the insured peril. Now, my lords, it's not clear what the court meant by inextricability in 348. The peril, the prevention of access by reason of a government order to close in response to the emergency, is obviously related to the emergency which prompts the government order. But the emergency had economic effects, and indeed continues to have economic effects, quite apart from the government action or advice which required closure of the premises in March 2020. We know from the assumed facts that some businesses were suffering losses caused by the emergency before the closure orders. We know that the emergency continued to have adverse economic effects for many of the businesses which remained open, which were permitted to remain open between April and July 2020. And we know that premises that were required to close were permitted to reopen, generally from the 4th of July 2020, but the emergency and its economic effects continued beyond the date when they were permitted to reopen, indeed continue to this day. And these points clearly demonstrate that there is no inextricability between the emergency and the prevention of access. Separating out losses from the closure, separating out losses caused by the closure from the other effects of the virus which are uninsured is a matter of adjustment. And as Mr. Gazeman reminded you, adjustment exercises are often far from straightforward, where one is seeking to establish trading results. As the Orient Express Award recorded, all claims for business interruption raise hypothetical issues, and whilst the tribunal would acknowledge that the evaluation required on the facts of the present dispute is more difficult than most, this cannot affect what is the correct approach in principle. And my lords, there was certainly no accounting or adjusting evidence before the court which would support a finding of impracticality. And the declarations which rule out attempts to adjust the loss in accordance with what we say is the true position under the contract are simply wrong as a matter of law. My lords, I have reached the conclusion of all that I propose to say orally. I obviously adopt what's set out in our written case. Unless your lordships have any questions for me, that is all I propose to say.
Well, thank you very much, Mr. Lockie. Well, at this stage in the appeal, we turn to the response on behalf of the Financial Conduct Authority, whose counsel making the submissions will be Mr. Edelman. Counsel. Mr. Edelman, it scarcely seems worthwhile inviting you to begin now. So we'll adjourn just now. Clearly, we'll take account of the fact that you're starting a quarter of an hour later than had been scheduled. So we'll adjourn for, just now and resume at 2 o'clock.